Hello, my name is Harvey Brownstone, and I'm a family court judge. I'm very proud and excited to be launching a brand new series of broadcasts which I'm calling Family Matters. This is a new kind of talk show created to educate and enlighten parents and families about issues that are of importance to the modern North American family. Last year, I released a book called Tug of War, which was the first book by a sitting Canadian family court judge that speaks directly to you, the public. I wanted parents to get the best possible information directly from a judge about the realities of family court and the alternatives available to litigation, so that parents could make informed decisions about how to resolve parenting disputes in a way that meets the best interests of their children. The public and the media response to Tug of War was overwhelming and got me thinking about more ways to bring the law and the justice system to the public in an easily accessible way. Over the past year, I've appeared on dozens of radio and television interview shows, and I went on a cross-Canada speaking tour. I've also conducted online Q&A sessions for the Globe and Mail and the Advice Scene website. I've had the opportunity to respond to all kinds of questions about family law and the family court system. This experience over the past year has made it clear to me that the public is hungry for reliable, useful information about the law and the justice system, especially if that information can be delivered in language that is simple and easy to understand. I truly believe that judges should not just be adjudicators in the courtroom, but also public educators. And while we judges cannot give legal advice or comment on political issues or on individual cases, there's a lot of information and insights that we can share with the public. Actually, we do it every day in our courtrooms, but often by the time people are in the courtroom, standing before the judge, it's too late for them. They've already launched themselves into a protracted, potentially catastrophic, high-conflict court battle, which may have very long-lasting and negative impacts on their family relationships. And so this show, the first ever to be hosted by a real sitting judge, will provide parents and the whole family with a lot of information and also access to people that you might not normally have an opportunity to hear from. I'll be bringing guests on the show from a variety of fields: law, mental health, education, social work, as well as some well-known authors and personalities to give you a candid, frank, inside look at the workings of the justice system and the issues that matter to you and to your family. Issues about families and relationships, how relationships are created, how they break down, and what happens afterwards. And as often as possible, I want to examine issues that impact on the well-being of children, who are, after all, our most precious resource. I hope you'll benefit from these broadcasts, and I invite you to drop me a line at info@familymatterstv.com and give me your feedback and your questions and your suggestions and any ideas you might have about future shows. You can also post your comments on our show's website. This show is for you, and I will do my best to address topics that you care about relating to the justice system and especially the well-being of families. Which brings me to several important cautionary notes that I want to make perfectly clear right from the start. Number one, I am making no money from this show. However, I have directed the production company to send a portion of the proceeds from the show to children's charities. Number two, you will from time to time meet various lawyers, mental health professionals, and other experts on the show. None of them will be receiving any payment for appearing on the program. This is a purely educational show. I'll be asking these experts to talk frankly and candidly about their work and about the issues that we're going to be discussing, and I want them to give us their opinions on a variety of issues. But as a sitting judge, I'm not going to be expressing many of my own opinions because I must remain impartial and neutral. I'll be doing my best to explore important issues in an unbiased, balanced, and hopefully refreshing way. I'm going to ask my guests the questions that I think you would want to ask, based on my experiences with litigants in the courtroom. But I want to make it perfectly clear that I am not necessarily adopting the opinions or the positions of any of my guests. Number 3, from time to time, there may be advertisers and sponsors helping to finance this show. I have absolutely nothing to do with that side of the operation, and in no way am I endorsing any of the businesses or charities that have chosen to advertise on this show. In particular, none of the law firms who've paid for advertising on the show appear at the North Toronto Family Court in Toronto, where I preside. Now, with all of that out of the way, let's start our first show. Thank you for watching, and I hope you'll find these programs interesting and helpful. Hello, I'm Justice Harvey Brownstone, and this is Family Matters. There's one thing that every one of us has in common, and that is that we were all children once. When parents can't agree on parenting issues, one of the hardest things for a judge to do is to determine what is in the best interest of the child. How does the voice of the child get before the judge so that we know what a child is thinking and how the parental conflict is impacting on the child? Today, I'm privileged to introduce you to 2 longtime dedicated lawyers who have the responsibility of advocating and representing children in court. With me today is Dan Goldberg, who is Senior Counsel at the Office of the Children's Lawyer in Ontario, and Katina Kavasilis, who is a lawyer at the Office of the Children's Lawyer. Welcome, and thank you both for being here today. I want to ask you, Katina, you've been a lawyer 26 years.
I have been.
And for the last 6 years, you've been a lawyer representing children. What were you doing before that?
Well, I was representing children before that, but as a panel lawyer, I was in private practice for 20 years. I've actually been representing children since '82.
And that was as part of a roster that the office has of lawyers?
We have a panel across the entire province.
And then you decided to go to the Office of the Children's Lawyer full-time?
Correct.
And Dan, you've been there almost your entire career. You've been a lawyer for 28 years, and 26 of them you've been at the Office of the Children's Lawyer.
Correct.
You must have seen a lot of changes in family law over those years.
Well, there are positive changes over the last number of years. The family law, discipline of family law has moved towards more settlement, more non-adversarial approaches to family law, which is very gratifying.
What made you want to represent children? It's a very delicate and fragile kind of area of law to work in. What drew you to this?
Well, when I graduated law school, I was very idealistic and thought that I can use my skills to help people, and there are no more vulnerable people to help than children. And I found using my skill set to help children has been an enormously gratifying experience for me. But more importantly, I think that I've learned a lot from children, and now that I'm a parent, I can use some of those skills that I've learned in interacting with children and helping them to better parent my own child.
Katina, you've represented parents, you've represented children's aid societies, and you've represented children a long time. Is there a big difference in how you do your job?
I don't think there's a difference in terms of how I advocate on behalf of the client, but I think my focus is different if I'm representing children.
So you're in the office of the children's lawyer here in Ontario. Is there a parallel department in every jurisdiction in Canada that does what you do?
I think not only are we a unique office in Canada, we're a unique office in the world. Ontario is a very progressive jurisdiction, and there is no one office that I'm aware of anywhere in the world that both have a legal representation program for children in child protection cases and in custody and access cases, a formalized system where children are appointed lawyers. So it's a very, very positive development that we have in Ontario. Some of the provinces throughout Canada have systems where lawyers are provided for children in child protection cases, but nowhere do children get the benefit of counsel, not only in family law matters, but our office also represents children where they have property or monetary interests.
So the Office of the Children's Lawyer is really quite unique in this country and in the world. What kind of training do lawyers get to be able to represent young children and adolescents and teenagers? They don't teach us this in law school. How do you learn how to do it?
I mean, the classes in law school are few and far between dealing with children. If you're lucky, you have one child in the law class as part of the programming. But our panel has mandatory training twice a year. Plus we bring in special speakers like Mindy Mitnick we had in recently, that the entire panel was invited down from all over the province.
She's a child psychologist.
She is, and she did a full day training on interviewing children for us.
So do you learn a lot about the developmental stages of growing up and the levels of understanding that children have?
We learn about the ages and stages of children, their cognitive development, and how to interview children, how to ask appropriate questions and age-appropriate questions in language that is understandable to them, that is most likely to yield an accurate information for us to be able to use in court before judges.
It's really quite a solemn responsibility when you consider that a child who might be in the middle of a lot of conflict meets a lawyer, maybe not even knowing what a lawyer is or what they do, and trying to get them comfortable enough to be able to communicate with you meaningfully. Is it a real challenge?
It can be a challenge, and it is a huge responsibility. And I think all of us have developed techniques that assist us in interviewing children, depending on their age, their interests, even their sex.
So one of the things that I think is important for folks to understand is we don't interview children once and go back and think that's the definitive, the categorical information that we're getting off that one interview. We interview children on multiple occasions in locations that are comfortable and familiar to them, such as schools, sometimes their homes if it's a comfortable location and there's a degree of privacy. So
you may be the only lawyers that actually do house calls.
We do house calls. And I think the critical thing about representing children is that we do multiple interviews, because one of the things we're trying to gauge when we interview children is their consistency, the consistency of the views and preferences that they have. So if we were just to interview a child once, we may see that child after, say, there's been a visit with a parent to Canada's Wonderland, whereas if we interviewed the child 2 weeks later on a Monday morning, and it was a less glamorous weekend that the child had, say, with a non-custodial parent, it may yield completely different information.
So let's take a little, have a little discussion here about what kinds of cases you get involved in, because I wouldn't want to give people the impression that every time parents come to court in disagreement with each other that the Children's Lawyer's Office gets involved. So starting first with the cases where parents are in conflict, what kinds of cases do you get involved? How does it start?
Well, the triggering mechanism is a judge must make an order for us to get involved, seeking our involvement. The judge would make an order. The parties have, say, 10 days to file intake forms, which provide information to us to determine whether or not we should become involved. And
what would be, as best as you can describe, what kind of factors would come into play that would make a judge decide that this might be the right kind of case for the Children's Lawyer's Office to intervene?
Well, it could be mobility, it could be high conflict.
Mobility meaning that if one
of
of
the
parents
parties wants to move out of the jurisdiction, there could be allegations of alienation, there could be domestic violence. I think every case is determined on its own fact situation and the judge's comfort level with dealing with the issues in front of them.
So is it fair to say that probably the more serious disputes, the more conflicted disputes are the ones where your office is requested to get involved?
Absolutely.
So then a judge makes an order asking your office to get involved, and then what happens after that?
Well, as I said, the parties, say mom and dad, have 10 days to complete an intake form, comes into the office, it's reviewed, and a determination is made, A, if we should get involved, and if we do, what service to provide. It could be a lawyer with a clinical investigator who is basically a person with a social work background, or is it a case that's appropriate only for a social worker or the clinical investigator to prepare a report to the court with recommendations.
So the name, really, your office, which is the Office of the Children's Lawyer, it's a little bit incomplete because you actually have a whole other side of your operation, which is comprised of social workers that are doing investigations and then writing reports to the court.
Yes.
So what kind of case, let's say that the Children's Lawyer's Office agrees that they should get involved. What would make them decide to have a social work report as opposed to assign a lawyer to the child?
Well, I don't think you can answer that question in a vacuum. We would look at the facts of the case. Realistically, if you have a very young child, an infant, having a lawyer appointed is of very little use because you can't ascertain views and preferences, and there may be clinical issues that the investigator is better suited to deal with. If you have a 14-year-old, you probably will have a lawyer appointed. They can have discussions with you and tell you what they want.
And if the office decides that they're going to have a social work intervention by way of an investigation, and then they write a report for the court, how long does that take?
Well, it depends, because ideally we'd like to do it in, say, 90 days to 120 days. However, it's a function of the parents making themselves available. They have to do multiple interviews as well. And so ideally it's done in a few months, but it can take longer depending on the availability of the parties to make not just themselves available, but the children available. In addition to that, the lawyers, both the lawyers and the clinical investigators within the office, conduct collateral source checks. That is to say, we check with teachers, physicians, therapists that are involved with the child so as to get as much information about the child that pertains to the child's interest as possible.
So it's a kind of a fact-gathering exercise. Is it the same thing as what we call an assessment? Or in the United States, they call it an evaluation?
No. If we're providing legal representation?
No, the investigation and report. Is that the same thing as an assessment?
No. They're not, I mean, they may make recommendations, but they're not doing a clinical analysis, and it is a fact-finding mission. They're providing the court with enough information to enable the court to make a reasoned decision.
So in what kinds of cases would the Children's Lawyer's Office do an investigation and give a report to the court, and as opposed to getting a lawyer assigned to the case?
I don't think there's an easy answer to that. We look at the facts of the case and make a determination who would provide the better service for the particular child in question.
Ontario is a very big province. How does the Office of the Children's Lawyer provide services throughout the whole province?
Well, we have a roster or a panel of about 375 lawyers throughout Ontario who apply to be on our panel, and once accepted, we train them and supervise them on their files. And we also have a roster of clinical investigators, again with a social work background, and there are about 150 of them who also work on a fee-for-service basis and both assist the lawyers out in throughout the province as well as prepare the children's lawyer reports.
Now, in those cases where we've been talking so far really about the cases where parents are in dispute with each other, but there's a whole other side to family law, and that's the area of child protection. Child abuse, child neglect, cases where the Children's Aid Society has had to intervene and perhaps apprehend a child. Do children get represented in those cases too?
Absolutely.
And how does that work?
Well, once a court order is made and sent to our office, we will appoint a lawyer to represent the child in question.
That must be extremely challenging to represent children who have who may be the most vulnerable children in our society.
So it is challenging, but that's probably the most meaningful work that our panel actually does. And I think it's the type of work that you actually provide a lot of good, you provide a lot of assistance to the court, and at the end of the day, you're really happy with what you did.
I think one of the distinctions that needs to be articulated is that in these types of cases, child protection cases, the Children's Aid Society represents the state's interests in protecting the child, and child's counsel represents the child's stated interests and views and preferences, which may be at odds with what the Children's Aid Society is seeking.
But is there a lawyer represented for the child in every single Children's Aid case?
Every time a judge makes an order appointing child's counsel, we are obligated under the legislation, Child and Family Services Act, to provide a lawyer for that child. That should be contrasted in custody and access cases where when a judge makes an order, it is not mandatory upon the Office of the Children's Lawyer to appoint child's counsel.
Yes, I can tell you as a family court judge, in cases where parents are litigating with each other, I find it helpful to ask the Children's Lawyer's Office to intervene if there's a serious issue that I can't resolve with the evidence the parents have given me. In a Children's Aid case, when do you think a child needs to have a lawyer? Because I don't think that judges appoint lawyers for children in every single child protection case.
No, they don't. But
do you see a pattern of the types of cases where judges feel that a child should have a lawyer?
Well, with older children who can state their views and preferences, many judges will appoint counsel for them. And in a lot of instances, there isn't a parent before the court. Even with a very, very young child, the court will appoint a lawyer for that child to ensure that their interests are being protected and the case is moving through the courts on a timely basis.
But isn't it the judge's job to protect the child's interest?
I think it's everybody's job to protect the child's interest, but the child has a right to have his or her views put before the court regardless of whether what I think or what I perceive to be in that child's best interest. The child has a right to have his or her views considered by the judge.
Now, I'm sure everybody watching this broadcast is probably wondering, how do you ascertain a child's views? How do you know what a child really feels and wants?
As I mentioned earlier, Justice Brownstone, we have, there's a three-pronged test that we look at. And one of those prongs is consistency of a child's views and preferences. So by definition, that means we conduct multiple interviews of a child. The second prong of this three-pronged test is the strength of a child's views and preferences. Is a child ambivalent? Is a child wavering in what they want? Or is a child pretty clearly stating what they want? And the third and perhaps most controversial prong of this test is the independence of a child's views and preferences. Is a child able to form and communicate wishes independent of his or her parents or other people? Or is a child communicating views and preferences as a function of influence that's being brought to bear on that child?
Well, what do you say to parents who say, I know my child, I'm closer to my child than you'll ever be, and I know that my child's views are completely different from what you're saying to the court the child wants? What do you say to parents in that situation?
I mean, we agree with them that they do know their child a lot better than we'll ever know them. I mean, we're involved for a very short period of time. But we also tell them that a lot of times children can't tell their parents how they really feel. They love them, they don't want to hurt them, but with us, I mean, they don't have a vested interest in being untruthful with us, and they will tell us in many instances exactly how they feel, what they want.
Do you ever get cases where a child doesn't want their parents to know what they really want because they're afraid?
Sure.
Always.
And we serve as a lightning rod often to take some of the, deflect some of the attention to the child's views and preferences and frame what the child is saying in a way that will make that child feel more comfortable. So for example, in a relocation case where a parent wants to move from one city to another city, we may say the child has a preference to remain, say, in Toronto where the child lives because the child's attached to the community, attached to the school, has extended family here, is involved in extracurricular activities, as opposed to saying the child prefers one parent over the other.
Do you ever get cases where a child doesn't have any view or preference? They can't really express whatever the options are. The child doesn't really have a favorite one?
I think we all get cases like that. Even you have children who love both their parents, know that both their parents can provide for them, and they want someone else to make the decision for them. Either you, the court, the next door neighbor. I mean, they want someone else to make that decision.
And actually, that's sort of the ideal sort of circumstance, because the child loves and has a good relationship with both parents. And who amongst us, child or adult, would want to choose one parent over another? It's an unfair burden to put upon a child, and hopefully, as child's counsel, we never ask the question, with which parent do you want to live?
Now that might surprise a lot of
Right.
parents to know that you don't ever ask the child the precise question that in the parent's mind is exactly what we would want them to tell us.
And the reason for that is we don't need to do that, because we spend so much time with our child clients. We do these multiple interviews that we get to know them and what they want without ever having to put that question, which not only is an unfair burden to a child, but also is a risk of making that child feel omnipotent. Whatever I want to happen is necessarily going to happen.
Well, often I've found that children really want their parents to get back together, or sometimes they'll say they want their parents to just stop fighting. They want them to just stop the fight.
That is a common occurrence.
And do you ever speak to the parents about that and help them understand how painful this is for their children?
Well, I think during the disclosure meetings, all of us do disclosure meetings with the parties.
What's that?
It's after we finish doing all the interviews and gathering all the collateral information that we think is required, we will meet with the parties and their lawyers if they have them, and talk about the information we've gathered, the interviews we've conducted, and the position we would be taking if this matter proceeded further.
Now, I've got to ask you this. There must be cases where a child's views or preferences, let's say in a children's aid case, are very clear and very consistent and very strong, but what the child wants is not, it's either not practical, not feasible, or not in their best interest. I'm thinking of a case maybe where a child would like to return home to a parent who has been abusive. Does that ever happen?
Well, that happens a lot. I mean, children love their parents, irrespective of how abusive, neglectful that parent has been. And most children want their families intact. It's the devil they know, as opposed to living in a strange home, sometimes in a strange community, and going to a new school.
Dan, how does the age of the child factor into all of this? I mean, assuming that you've got a child whose views are consistent and they're strong and they're independent, would the views of a 5-year-old be treated the same as the views of a 14-year-old?
I think, Justice Brownstone, there's a recognition that very young children, although their wishes are important and they will be placed before the court, placed in evidence before the court by a children's lawyer, they are not as weighty with the court, and as a result, we have to get other information before the court, other information which contextualizes and supplements the child's views and preferences. So we may go to a daycare or a school to speak with the daycare teacher or the school teacher, talk to the child's pediatrician, anybody who can really shed some light on that child. And with respect to an older child, we would perhaps do the same things, but their wishes are obviously more weighty with the court. Their cognitive skills are much more developed, or the level of cognition is much more developed, and as a result, we would recognize that courts place much more importance on the views and preferences of a 14, 15-year-old than, say, a 3 or 5-year-old. And as a result, it calls upon us to put more information before the court, to make sure we do as much work as possible to get all the collateral information before a judge.
So let's just talk a little bit here about the parents. I get the impression sometimes in court that parents may not understand the role of a child's lawyer and the function of a lawyer that represents a child. I mean, let's face it, most of us as children didn't have lawyers, and many of the parents in our court don't even have lawyers. What do you want to say to parents who may find themselves in a dispute with each other and in the position of having their child having their own lawyer?
Well, I think one of the things parents need to understand is that we didn't voluntarily come into this case. A judge thought it was important that their child have independent legal representation. And we start off representing a child in each case from an independent and neutral perspective. We don't have a vested interest in either parent, in supporting either parent. Having said that, lawyers take positions on behalf of their clients, and so too do children's lawyers. So when we finished doing our several interviews with our child clients, our interviews with parents, which we do to understand how they see the case, as well as the collateral information that we're ascertaining, after we do all of that, we take a position, and it may support in whole or in part one of the parents. And while we lose our neutrality because we take a position, which inherently means that you're no longer neutral, we've come at it from a completely independent perspective. We're independent at the beginning of the case, the middle of the case, and the end of the case. We're independent of the parents.
Now, what does that mean in practical terms? That you're not accountable to them, and you're being paid for by the government. So even if the parents did have lawyers, let's say legal aid, the legal aid isn't paying for your services.
No.
So you're independent really in every respect.
Yes, we're independent in every respect. We owe a fiduciary duty to our child clients. We have to do what's in their interests and what serves their interests well. And their interests mean not necessarily their short-term interests, but also their long-term interests have to be taken into consideration.
If I may add, and their interests may not necessarily be in accordance with their stated wishes.
But you always advocate the wishes of the child in context.
Correct.
So that the court has all of the information in order to assess how much weight, I guess, to put on the child's
But I think Katina raised
position.
a good point, and the point is that if one of those prongs of that test, the three-prong test, is not met, say the child is not able to form views and preferences independent of a parent, that is to say they've been influenced to take a position by a parent, then, and there's evidence to that effect. It's not my or Katina's personal opinion, but there's evidence before the court that that child's been influenced, then we will still put those wishes before the court, but we are not bound, we don't feel bound to advocate them, because in essence we'd be advocating the position of the offending parent.
Well, that was the big white elephant in the room, parental alienation. We're hearing about it all over the place. It's in the media. It seems to be the new buzzword, certainly in family court, over the past few years. Is it easy to detect when parental alienation has occurred when you're meeting with your clients?
Well, I think that if you've been doing this work for a long time, or even if you haven't been doing it for a long time, children speak in age-inappropriate language. They have a rehearsed, robotic quality to what they're saying, so that very often their experience with the parent that they say they're alienated from is at variance from reality. So kids may say something like, the language they use may be, I had a 7-year-old who came into my office a number of years ago, sat down in my office with her very, very prim and proper little girl, and said, I want exclusive possession of the matrimonial home.
Oh, instead of exclusive possession.
Correct.
7 years old.
7 years old. And then I had a 9-year-old boy come in a few years ago, and he wanted his dad to be kept away from his home, and he said, I want a training order. My mother and I want a training order, whereas he really wanted to say restraining order. So, this is not something that, these words or these buzzwords are not words that normally young children would have any awareness of.
Do you have a definition of parental alienation that you subscribe to?
I don't. Not one set definition.
I think that the general understanding of the term is that one parent has gone on a campaign to poison the child against the other parent, turn the child against the other parent without any justification. And the child turns against that parent without, for no good reason. That seems to be the definition that a lot of people rely on, and we certainly do see some cases where that happens. So what do you do in that case where the evidence shows you that the child's hatred of the other parent isn't justified?
I think it depends on how long it's been going on. I mean, the sad reality is after a period of time, there's very little that may be able to be done.
And
what if it hasn't been going on very long?
I think as a general proposition, the earlier you get involved in a case to take steps to address the alienation, and that may be getting a child and parents to some counseling, because very often in alienation cases, a child's sense of reality is severely distorted. They see a parent in a way that is, again, perhaps at variance with the reality of the situation. And how do you correct that? Lawyers aren't necessarily trained to do that. What lawyers can do is assist the parties in getting, and the court if necessary, to make an order to get this child to get some therapy.
Have you ever had to get a Children's Aid Society involved in a case?
There's been occasion when the Children's Aid has been notified because of the level of conflict and how it was impacting on our child client.
I think that a lot of people still don't understand that part of child abuse can include emotional abuse, and that being caught in the middle of a parental conflict is a form of child abuse, this conflict of loyalties. And that sometimes when the conflict between the parents gets so high, it becomes a child protection issue, not just a contest between the two parents anymore.
Absolutely.
Do you ever see that coming, and are you able to do anything about it?
I'm going to say we all try to do something about it. The last thing we want is our child client harmed in any way, physical, emotional, or otherwise. Sometimes, unfortunately, there's nothing we can do about it. And the Children's Aid Society has to become involved and to get it before the Child Protection Court, to have people refocus on the child as opposed to their battle.
It seems to me almost overwhelming that so many parents can't overcome this kind of tunnel vision that they have about their conflict, and that they don't seem to realize the pain and the torture that their children are going through as they battle out this war. Isn't there something that we can say to parents that can help them rise above this so they understand that if they don't stop the fight, they can lose their kids?
Well, I think it's important for all of us in the system, social workers, lawyers, judges, to understand that the people that are coming before us are going through the most difficult times of their lives. They're divorcing, they're losing their life partner, they're losing perhaps their home. They're economically challenged at that time. Their finances may be very stretched. And they themselves are may be the most giving, stable person in normal times, but these are far from normal times that they're experiencing. And as a result, they perhaps have less to give to their child than they normally would. So it's the job of all the people in the system to make sure that the focus of the litigation and the proceedings deals with the child and what we can all do to make that child get through this with as little damage as possible. And that means perhaps being blunt with parents by saying that what they may be doing to a child, perhaps telling the child to pass messages along to the other parent, to be the vehicle of communication because one parent can't speak to the other parent. Doing things like that is not in the child's interest. And we have to share that with parents, and sometimes parents don't even realize what they're doing is a negative thing, and once they realize it, they stop doing it. Some parents can, some parents can't.
Katina, can you describe for us some of the things you've seen parents do that's inappropriate with their children? Dan talked about using the children as messengers to deliver messages. Are there other pitfalls that parents fall into sometimes because they don't communicate with each other?
Well, just berating the other parent in the presence of the child.
Speaking badly about, bad-mouthing each other to the children?
Bad-mouthing each other, or bad-mouthing the other parent's new partner. talking about the other parent's inadequacies, again, in front of the child.
All of those things are big, big no-nos.
They're huge no-nos, and especially for children. Children love both their parents. And what you're doing is creating a situation where you're actually hurting the child when you talk about their other parent in such a bad way.
You know, it's a question that I've always wanted to ask, being a judge myself. When do you think it's right or good for a child to come to court? Because sometimes the children's lawyer will bring the child to court with them, and other times the child's not there. And I've always wondered what goes into that decision about whether the child should come.
Well, in child protection, if the child's 12 and over, they have the right to come to court unless a
And
judge...
this is in Ontario.
In Ontario, unless a judge decides that something in that proceeding will be harmful for the child.
So staying with child protection for a minute, do most kids over 12 want to come to court?
No, not at all. Most children
Does that surprise you?
No. Most children have a fear of court. They watch court on television. They see Law and Order, the criminal programs, and court is someplace you go if you've been bad. So for them, it's not something that they're interested in. Older children more so have more of an interest in court than like a 12, 13-year-old may not be interested, whereas a 15, 16-year-old might.
And do you think that for the ones that want to come to court, is it generally a positive experience for them? Because we don't see them when they leave the courtroom. You know, we judges don't know what impact that court appearance has had on them. But you as their lawyer, can it be a healing experience sometimes?
Most times when children come to court, it's usually on a consent matter. I mean, the reality is there's very few contested proceedings at court that you would have a child sit in and listen to, because there is a lot of information that is brought forth that can be harmful to a child, or it can be saddening to a child. I mean, no one wants to sit there and hear about how inadequate their parent is for 3 hours. I mean, that is difficult.
Even if they're an adolescent or a teenager?
Even, you know what, I'm 53, and I don't think I could sit there for a few hours and hear about my parents' inadequacies. And I like to think I'm a mature, intact human being. I'm not an adolescent who has gone through the child protection system, who's had an inadequate parenting background, and who has perhaps some needs.
Do some children want to talk to the judge, come to court with you and speak up in the court case?
Some.
And is that okay, or do you feel that they should let you do the talking to speak for them? Just as many lawyers that represent adults will say they would prefer that the adults not speak and let the lawyer talk.
And in fact, though, and a lot of judges tell the clients to keep quiet and let your lawyer speak for you. That's why they're here.
But if your client wants to speak to the judge, will you say to the client, to the judge, I'd like, my client wants to talk to you?
Ultimately, you may advise your client that it may not be as to the pros and cons of doing it, but ultimately if the child is adamant about doing it, then we would advise the court accordingly.
Now, in a domestic matter where parents are arguing with each other, usually custody and access, I've never seen a child come to court.
Well, I think it's our experience, the colleagues that we have, as well as our own experience, that very, very few children want to come to court in a domestic proceeding.
It's a shame their parents don't feel the same way.
Well, the interesting part of it is the few children that do come to court typically do so at the behest of one of the parents. That is to say, they want the judge to hear what the child has to say because they believe that the children's lawyer isn't necessarily going to put it forward in a way that they like. So we will say what the child has said, but we'll contextualize it because perhaps we don't feel the child is saying it independently, whereas the child, they want their child to go directly to the decision maker and tell the judge directly what they want, even if it's as a function of excessive influence.
It sounds like one of the really important messages that you want parents to hear, at least it's coming loud and clear to me, is that if you have a child who's had a lawyer appointed, back off. Don't tell the child what to say. Don't interrogate the child. Let the child express their views and preferences without interference from you.
Yes, and if you do try to influence the child, it's going to be pretty clear that you're doing it. It's not hard, again, it's not hard to know it because the child's language won't be natural, it won't be spontaneous, it won't be age appropriate, and it'll have this rehearsed robotic quality to it. So, but again, we have no interest in the case other than ensuring that our child's client's welfare is being brought forward. So, work with us because ultimately, as Katina mentioned earlier, when we finished our work, we hold a disclosure meeting, which hopefully leads to some form of a settlement. We actively, because we're uniquely positioned, because we're independent of mom and independent of dad, we're uniquely positioned to try to effect a settlement in the case.
I have noticed that in a lot of cases where mothers and fathers are in conflict and a children's lawyer has been appointed, that the child's lawyer is able to reach the parents from that perspective of the child's voice and helping them reach peace. And it seems to be a very effective way for parents to finally understand that their child's lawyer has the voice of reason in all of this.
And most people want to do the best for their children. And most people, once they realize the harm their actions are causing on their children, tend to back off. I mean, it's that very small minority who are so engaged in the battle that they forget there's children involved.
Now, I should ask you this just for some advice to parents. There are lots of cases, as we mentioned, where parents are in conflict and the children's lawyer is not involved. And sometimes we judges get parents coming to court with letters that they want the judge to read, letters from the child. And of course, we don't know the children. We don't know who wrote the letter. We don't know whether someone dictated it to the child. You have anything to say to parents who really are so afraid that the judge won't get it, won't understand how their child feels, and we don't have the privilege of having you there?
I mean, it's an enormous challenge to judges to confront a situation where there's nobody there. You may have two people who are representing themselves who don't have the assistance of lawyers to help put their case forward. You're in a situation where there's nobody there to give you an independent perspective of what's going on in the family. So, having said that, there are certainly pros and cons of taking in information such as letters. And of course, you identified it yourself, Justice Brownstone, by saying you don't know who was hovering over that child when that child penned that letter. You don't know who may have been hovering over that child when the tape recording that is offered to you is being made. So it's certainly your prerogative to hear that evidence, but of course you have to, you judges and everybody in the system has to understand that they have to be taken in that context. They may be of great probative value or very weighty with the court, or they may be of limited or no use with the court because of the circumstances in which the evidence was created.
Can I just make one comment? I mean, in Ontario, custody is decided and access on the best interests of the child. Views and preferences are just one of the considerations the court has, and I think people forget that. There's several things that a judge needs to weigh in coming to their decision, and not just views and preferences. So what a 13-year-old wants is not going to be determinative of the issue for the court.
I'm so glad you raised that. I can't understand sometimes how parents really do, many do, not everybody, many do think that their child's wishes, even if they're very young, 5, 6, 7, this child doesn't want to go to see the other parent, would govern. And I say to parents, what if your child didn't want to go to school or didn't want to go to the dentist? I don't know any children that want to go to the dentist. And parents immediately will say, well, of course I would make them do that. But other times, if it's an issue that resonates with the parent on some kind of emotional level, often a parent will have no problem allowing the child to decide it.
Again, as I said earlier, for these folks, I think a lot of the stakes are very high. The children are their most important, precious things in their lives, and they lose sight of what's going on and what's perhaps in the best interest of their child, and they make the child feel at times that what they have to say is going to be determinative. And it isn't going to be determinative regardless of whether the child's 6 or whether the child's 14. There, as Katina mentioned, there are a number of factors that are taken into consideration, and the views and preferences of a child are just but one. Again, the older the child, perhaps the more weighty, but still, they're not determinative.
And that's something that we make sure our child clients understand, that the court is very much interested in what they have to say, but they are not the decision makers in this.
So even the children know
Well,
that it's not their decision.
that I've told every child client of mine that from
How do they
time-
take it?
Most of them understand. They tend not to be the decision makers in a lot. I mean,
But when we were
teenagers-
all kids, we all wanted our own way. I
I
would have
still
thrown a
want my
fit.
own way, but the reality is there's rules. And other people sometimes make decisions for you, and especially as a child. They determine your bedtime. They determine whether you're going to go to school. You don't have that decision-making power.
Mind you, we lately, I think, we're seeing this phenomenon of the parentified child. Children that seem far older than they should be, children who know much more about the parental conflict than they should for their age, and who seem to become the caregiver for the parent. Do you see that in your work?
I mean, parentified children have been around since before I started practicing. You tend to see them more in child protection cases where they're actually parenting the parent.
A
But you
parent
see-
who's got real problems,
No, but
perhaps
there's-
mental health problems,
or drug addictions, or I mean, there's a variety of reasons why parents are inadequate and children have to step up to the plate.
And what happens to children that are parentified? Why is it seen as something bad? You know, a lot of people might be saying, well, when I was growing up, I was the older sibling. I had to do a lot of work at home, taking care of my younger siblings because my parents worked. And I grew up quickly and I got mature and I learned a lot of life skills. And
But I think there's
why
a
is
difference.
it bad?
Yeah, there's a difference between having the responsibility of assisting with the care of your younger siblings and being ultimately responsible for the care of your younger siblings
And for yourself.
and for yourself. I mean, I've had clients, not my own children, who their parents were drug addicts, and my oldest of the sibling group would go to the grocery store. She would steal bologna and bread to feed her younger siblings. She taught them all how to read and write, how to write their names. She toilet trained all of them because the parents were just not there. She was a parentified child.
And why is that a negative thing?
Well, part of what children are, and the relationship that parents and children have with one another, is parents are hopefully trying to meet the needs of their child rather than the child meeting the needs of the parent. So I think that, in short, is a definition of a parentified child, a child who's meeting the needs of their parent.
We sometimes forget who the parent is and who the child is.
Again-
when we're so caught up in our own
Correct.
troubles.
Because again, the parents are going through, along with their children, the worst times of their lives, and we have to ensure that we're supporting this family and getting them the help they need. At the same time, not burdening a child, overly burdening a child with responsibilities that really aren't that child's responsibilities. In fact, I'm sure that Katina and all our colleagues tell our child clients this regularly. Your job is to be a kid, and it isn't to necessarily look after your parents all the time. You know, some kids do look after their parents. Sometimes, if a parent gets sick and needs a little help, that's right. That's normal. But what's not normal is the regular, really parenting of a parent by the child. That really is not the child's role in the parent-child relationship.
Yes, we certainly see enough of that. And something else I'm seeing lately, I just wondered if you had any comments. You know, the whole world of internet dating has become the norm on how young people meet each other. And while these social networking sites are really very good in many ways, we're seeing people that are worlds apart, physically, geographically, as well as in every other way, linking up, getting together, having relationships that are very passionate at the beginning, and then they fizzle out, and there's a child that's been created out of the relationship. And then One of them wants to move back to whatever place they came from with the child, what you referred to earlier as a mobility case. Are you seeing a lot of mobility cases?
Not in the exact example you gave, but we're seeing mobility cases with people who meet their new partners on the internet and want to move to that partner's location, and the parent who's left behind is not happy. And is
So they're already in a relationship. And then they've already got a relationship with a child. They meet somebody else, and they want to move with that child to be with the new partner.
Exactly.
How do you? I guess if there's an investigation and report, it's the social work side of your department.
Clinical investigator.
The clinical investigators will do that. But are they able? Let's say someone wants to move to Argentina. Is your office able to really do an investigation to see whether it would be better for the child to move there or to stay here?
Well, I think that these relocation cases are challenging because if the home in Argentina is at issue, the actual physical home is an issue, then there's a problem associated with it because we can't go to Argentina to check out the home. But
so you can do house calls, but you don't get to travel.
We stay within our jurisdiction.
Yeah.
Stay within Ontario. What I have seen frequently is these long distance relationships, and I've had cases where they've been in Australia and New Zealand, where they've met over the internet. They've perhaps parents have come over, or the one partner's come over to Canada for a couple of weeks, and then the other one goes to New Zealand or Australia for a couple of weeks, and then they decide they're going to get married, and they don't really know each other very well, and when ultimately they want to move to Australia and disrupt, which would have the effect of disrupting the child's relationship with the non-custodial parent or non-residential parent, as well as extended family, as well as the child's connections with the community. It's, again, very, very challenging to deal with these cases because you're dealing with perhaps a decision that's not well grounded. If however, the relationship between mom, the parent and the new partner is more grounded and more cemented, then you're on more solid ground yourself in seeing where this is going to go and what may be in the best interest of your child client. But how can imagine a 15-year-old whose mother meets someone in New Zealand, and the mother's determined to go with that 15-year-old to New Zealand. That 15-year-old has a life here, and just because she's the custodial parent doesn't automatically mean that that child is necessarily going to go with that parent. And we have to ensure that everybody is aware of what that child wants and why that child wants it. And as I said earlier, it may not be a function of preferring the non-custodial parent over the custodial parent, but it's a function of preferring the stability of the existing community over the uncertainty of the new community.
These are really heart-wrenching cases that you have, and really delicate, fragile clients. Dan, you've been at the office now 26 years. Have you kept in touch with any of your clients? Many of them are parents now themselves.
You know, I had a case, a horrible case. It doesn't get worse than this. It was a murder-suicide case a number of years ago, and where the father murdered the mother and then took his own life. And there was one child, a boy, who at the time was about 9 or 10 years of age, and then fortunately a wonderful aunt came forward from the father's side. There was nobody else really that was a possible caregiver. And I just found out this very past week that the child's at Queen's University doing extraordinarily well. And it turns out that the aunt who came forward ultimately went to school to become a social worker and is now practicing social work. So this is one of these cases where you always wonder, can a child experience a more horrific thing with respect to his parents, and yet his life with the right support systems and the right love and care that was provided by this aunt and her own son, this child has done incredibly well. Having said that, we do lose touch with most of our child clients, and we don't know where things ultimately go with most. But and in a way, that's perhaps a good thing, because we shouldn't be involved very long with the child. Lawyers should be in and out of a child's life as quickly as possible to help that child in getting an arrangement which meets the child's needs, and then we should exit the scene as quickly as possible.
Well, I have to tell you on that note, this was a really penetrating and very informative look inside the work of the children's lawyer. And I have to tell you that I hope that you've had an impact on the parents watching today, because it really is all about the children. I have been a family court judge 15 years, and I think I've had only 5 cases where there were no children involved. Every other case, it was about the children. And so it's very, very important that we know how courts get the information that they need about the child's wishes and preferences. And I want to thank you both so much for taking the time to come and enlighten our audience about the very, very valuable work that you do. Thank you both very much for being here.
Well, thank you.
Thank you.
I'm Justice Harvey Brownstone, and this is Family Matters. See you next time.